Good morning from London and welcome to the first of our series of the Dentons Brexit implications conversations. My name's Stuart Hopper and I'm the head of knowledge at the firm. Joined for some high-level input into this fast-moving piece by Jeremy Cape, one of our tax partners, and Andrew Cheung, one of our regulatory and compliance partners. Our agenda is pretty fluid, owing to the fact that the situation is pretty fluid. It also reflects a lot of the things that we've been seeing already as questions, queries coming in from our clients. But I think three things are probably clear as we sit here this morning. The first, obviously, is that Britain has voted to leave the EU. The second is that the EU is, as a bloc, by far the UK's largest trading partner. And the third one, frankly, is that no one really knows what's going to happen next. On the political front, things have been moving again at incredible speed. Jeremy, you're a former political advisor to the Conservative Party. Could I ask you to say a few words about what you're seeing?
I think it was expected that there would be some political fallout in the event of a vote to leave the EU. It wasn't envisaged that we would have this sort of political fallout. I think perhaps what was envisaged was that Cameron might resign on Friday, as he then did, and that we would see a leadership contest in which the front runners would be Boris Johnson, Theresa May, maybe a few others. And it was also anticipated that the Labour Party may come under some pressure, and particularly Jeremy Corbyn, having run a lacklustre campaign in favour of remaining. We've seen what can only be described as a collapse of the Labour Party. But on the Conservative side, again, we were expecting to see a bruising fight, but we were also expecting to see Boris Johnson on a ticket with Michael Gove.
Politics, obviously, a crucial ingredient in the mix there. On the economic side, it's probably a good bet that one of the short-term impacts will be around UK assets becoming cheaper. But more generally, Andrew, can I bring you in to have a few words about what you're seeing sort of on the economic side?
Of course. Pound sterling is now at 30-year lows as against the US dollar, and that presents some opportunities. So there are always people in the market who are going to look to identify and exploit those opportunities. And certainly if you are a US investor looking to snap up a bargain in the UK, this could be a good time to do that. You'd have to pick your asset very wisely, but it could be a very good time to do that. It probably is bad news for a number of UK companies, particularly if they have high exposures to US dollars, and those who are looking to expand their operations internationally, because that's going to become more expensive. There are numerous surveys, both before and after the referendum, numerous studies done by economists looking at the anticipated effect of Brexit, and the latest, which has been referred to, is the Atradius survey, which is looking at predicting some pretty grim results for the UK economy in the short term, so in the next 2 years or so, where there is an expected 1 to 3% reduction of GDP, an increase of up to 4% of insolvencies in the UK, and increases again, less than that 4% number, but increases in insolvencies across Europe as the turmoil expands out to our closest trading partner and closest geographic neighbour. So not good news on the economic front, but opportunities depending on how your business is structured.
Interesting point that you mentioned in relation to the opportunities of a strengthened dollar in terms of dollar versus sterling situation. One of the things that we've actually been seeing, again, coming in from clients and contacts, is sellers actually increasing prices in the expectation that buyers, with their strengthened purchasing power, will they're looking to share some of the benefits of that, rather than just giving the entire benefits to the buying party. Again, another point, I suppose, that we need to consider around all of this is what are the mechanics of the situation in which we're in from a legal point of view. So again, maybe back to you, Andrew, to kick a few of those points around.
Yeah, of course. So a lot of the market volatility stems from uncertainty. that Brexit has introduced. And I think it is clear that there wasn't really a coherent visional plan from the Brexiteers as to exactly what they wanted a post-European Britain to look like. And that is reflected in the politics of the Conservative Party at the moment, I think, to a large degree as well. We can talk about that. A lot of that uncertainty stems from the process by which we actually invoke Article 50 of the Treaty of the European Union to leave the EU. So on the European side, it's relatively straightforward. Any member state can invoke Article 51 of the treaty, and that will see that member leave in accordance with its constitutional requirements. Once that notification is issued, that starts a period of negotiation. That period of negotiation extends for 2 years or can be unanimously extended for any other period of time beyond that. But that mechanism throws up some very interesting challenges from a UK perspective, from a UK constitutional perspective, and puts the EU in quite a strong negotiating position, because if an agreement is not reached on the terms of Britain's exit from the EU, then it will simply cease to be part of the EU automatically at the expiration of that period, which is why we're seeing so much political manoeuvring at a European level as well as at a British level as to when precisely the UK should issue its Article 50 notice, with the Europeans wanting that to happen as quickly as possible, though now it seems that they're accepting that they should at least wait until we have a new Prime Minister appointed.
Possibly a government.
Possibly a government, if there's anyone left to govern. But they will want that to happen quickly because they want to reduce uncertainty and reduce the impact of a Brexit contagion for the rest of the EU. But Britain will want to take its time, because irrespective of the mechanics, they have to go through a tremendous amount of work, run a parallel negotiating process, renegotiating the position under Article 50 with the EU at the same time as reviewing and planning for a potential exit from the European Union and all of its legislation. To put it in perspective, not just that won't just involve renegotiating international trade deals, which could be 28 different negotiations, 27 different negotiations within the EU, but all international trade treaties and other treaties, as well as reviewing over 80,000 pages of legislation within the UK that implement or are affected by EU legislation, and then looking at the EU legislation regulation, which binds the UK directly, and thinking about to what extent that should be transposed and reflected either through equivalence or other mechanisms in UK law. That process in itself is going to be coloured very significantly by the politics of the day and the electorate in the UK as to what's going to be acceptable to their Brexit vision and what isn't. Coming down to the UK level, there is a lack of clarity as to precisely how the UK can go about issuing its Article 50 notice. There are some points of view that suggest that the Prime Minister will be able to do that, relying on his royal prerogative to do so, or her royal prerogative to do so, depending on the outcomes of the leadership debate at the moment, or Parliament will need to pass an act to authorise the Prime Minister to be able to issue an Article 50 notice. And the difficulty there is one that's of arcane significance to constitutional lawyers, but the difficulty is the impact of issuing the Article 50 notice, because once it is issued, there isn't a... Exactly, the clock is ticking, and there isn't a mechanism under Article 50 or the Lisbon Treaty for the revocation of an Article 50 notice. It only deals with the terms of exit. I'm sure that some will argue who oppose Brexit that the mere issuance of an Article 50 notice puts Britain on the irrevocable path of exiting the EU, and that's going to have constitutional implications not just for the UK, not just for England, for the British Parliament, but also for its devolved legislatures. So.
Well, we've had a number of questions coming in from clients, not only around the procedure, how do we get to exit, but then what happens next. Maybe I could ask Jeremy, you to have a couple of words on that.
Yeah, I mean, let's just wind the clock back a little bit. During the referendum campaign, two things were assumed to be the case. One is that the referendum was determinatory of the question, and that if the people voted to leave the EU, we would in fact leave the EU, and two, that the Prime Minister, expected still to be Cameron, he said he would do this, would be the person to exercise the notification, and it was envisaged he would do that straight away. Now, on the first point, this by no means still seems clear, although as far as I can tell, none of the campaigners were saying this during the campaign. It is drafted as a recommendatory referendum. It is not binding on Parliament. But then leading to this second question, in recent days, I understand that many QC opinions have been asked for a very reasonable sum, I'm sure, and have been issued on the question of whether the Article 50 notification can be made by the government unilaterally under the royal prerogative that Andrew referred to, or whether there is a need for Parliament to pass an act in order for this notification to be given. But the assumption seems to be that if Parliament considers this question, there's at least a fighting chance that Parliament, with MPs who most of whom supported Remain, would vote not to issue that notification to the European Union. So we can expect, I think, to see whatever position is taken initially by the government, and I would assume that position will be that the Prime Minister can make the notification without going to Parliament, that will then be challenged. Someone will challenge this and the Supreme Court will readily hear it. So we'll be having the Supreme Court considering what the constitutional requirements are within the UK in relation to a notification procedure under the Treaty of Lisbon. This also raises then the rather exciting and controversial possibility that the Supreme Court may need to refer the question to the European Court of Justice to enable it to rule on whether Parliament is required to pass an act. So we could end up in a position where it is for the European Court of Justice, whose jurisprudence the leavers want us to be able to ignore, determining whether we do in fact leave the EU.
Interesting times. I think the one thing, the one clear fact that we can say is that unless and until the Article 50 procedure is triggered and we come to the end of that process, we currently, as the United Kingdom, remain part of the EU. And I think there are some other issues coming out of that might be helpful to explore. Andrew, do you want to go through a couple of those with us?
Yeah, I mean, I think that is the number one thing to remember. And what we're seeing is some initial market volatility in reaction to the uncertainty that the Brexit referendum has produced. But nothing has changed day one. We're still subject to EU law. We're still part of the EU until that Article 50 notice has been issued. And even at that point, whilst we will move to exit, no one precisely knows what the outcome is, but we could still find ourselves being bound by EU law in some form or another, depending on our status. Before I answer that question specifically, I think I'd like to just comment very briefly on what a prerogative power actually is. I mean, it's a peculiarly UK sort of thing. It's a collection of executive powers held by the king and stems from medieval times, and it's not documented. So it's a great area of uncertainty. It's usually used in foreign policy arenas, which empowers the government of the day to be able to make decisions without referring matters to Parliament. But there are and have been some celebrated limitations to the prerogative power. So it caused me to dust off the considerable amount of dust that lies on the 1610 proclamations case to try and understand how the prerogative power interplays with Parliament's legislative power. But it's generally held that the prerogative power does not allow the king to change the common law statute or the customs of the realm is the quote from that case, and that's been referred to in a number of subsequent decisions. So there are a lot of acts which incorporate EU law and implement EU law, in addition to the European Communities Act, which brought the UK into the Union. And there are some very strong arguments there that I think could be made that an Act of Parliament is required because to exercise the prerogative to issue an Article 50 notice is an irrevocable step, and that's going to impact on the rights and obligations of UK citizens in respect of Europe, which they have been granted under statute, but it's also going to cut across a whole swathe of legislation. So whatever happens, I think Jeremy is right, it's going to be challenged.
Yeah, but I think one has to be careful here a little bit, because let's suppose you have an Act of Parliament needed in order to serve the Article 50 notification. And let's suppose it does go to Parliament and Parliament votes against it. It doesn't end there. No. Right? We're concerned, our clients are concerned about this period of uncertainty. There is perhaps an idea, and I don't think the lawyers who are, the constitutional lawyers who are arguing for this and are seeing it in this particular way, but to the 52% who voted to leave, and they did it not just because of the EU but because of various other social and economic reasons, if you have Parliament then saying, well, we're sovereign, you told us we're sovereign, and we are going to not leave the EU, it doesn't end there. You're going to have a general election again. And you may find under that general election that you have MPs being elected who will wish that Article 50 notification to be served, and may have a more cohesive view of the European Union and our relationship with it after that general election. I think one has to be a little bit careful, and to the extent that anyone wishes to use this matter of constitutional law in order to get to another result, even if as you find yourself in this position that could lead to the Article 50 notification not being immediately served, it doesn't mean we remain the EU, and it doesn't mean that we can return to the land of milk and honey that we were before last Friday.
I think all of which brings us back to the uncertainty point. I'd like to pick up another thing, Andrew, you mentioned about the royal prerogative. I think one of the areas that we do know the royal prerogative has been limited is around taxation. And so, Jeremy, maybe I could go and come back to you and ask you a couple of questions or some thoughts around tax at this stage. I think tax and finance are some of the key questions we've been seeing coming in from clients. So maybe start with the tax.
Yes, I mean the UK tax system isn't as influenced by Europe as some may think that it is. The key areas which are influenced are VAT, value-added tax. It's a condition of entering into of joining the EU that you have a value-added tax system. Customs duties, that's a real issue. At the moment, you can move goods across the EU without customs duties arising, and that position is going to change. In the sphere of direct tax, whilst Parliament sets the tax laws, they are informed by certain requirements, essential freedoms imposed by Europe. So we have seen some changes to our tax laws that have been imposed because we wanted, or our laws treated a relationship between a UK and a French company differently from a UK to a UK company. The irony is that many of the changes that have come about through those decisions of the ECJ have actually made the UK more attractive to business from a tax point of view. So it would be odd if, having shaken off the shackles of the ECJ jurisprudence, that we would give up some of those benefits that actually ECJ jurisprudence has brought to the design of our system. But in terms of what happens practically, I mean, let's use VAT as the example. So we have a Value Added Tax Act, 1994 Act, which is heavily derived from European principles and is consistent with those, but also, to be fair, resembles VAT systems around the world, which are not required to be in accordance with the European system. That has to be in place in that form, I think, until 2 years after the Article 50 notification is served. What then happens, though, let's say it's 1st of January 2019, 1st January 2020, do we keep that old VAT Act, Do we amend it a bit? Do we rip it up and start with a new VAT Act which addresses some of the issues that the new government doesn't like about the old VAT Act? Parliament having time to debate these issues, just in terms of that ability physically to be able to do all this work in relation to legislation. Has it been thought through? I suspect not.
And the practical result because of that is probably that even if we were to exit completely from the single market and be truly sovereign again, across key, most if not all key parts of our legislature, it's just going to be flipped over and adapted in a rather rough and ready fashion, I imagine, to provide a sort of placeholder.
Yeah, but imagine that Queen's speech, right? You get the Queen's speech saying, "My government will enact all the European regulations because they don't have time to design their own."
Yeah. I wonder if there's a chance here just to have a bit of a crystal ball gaze. Going back, I think, to the point you raised, Jeremy, about looking at some of the practical issues and problems around how we deal with legislation. But in the tax sphere specifically, bringing in some of the political upheaval that we're seeing, I wonder whether, as I say, we could ask you to sort of crystal ball gaze slightly and maybe sketch out some scenarios where the politics affect how the government goes about its tax policy and what that might mean.
Well, we've already seen today, I think in the Times, a leader saying that the UK should cut its corporation tax from 20% to 10% to show that the new brave world of the UK is open to business. Now, my personal view is I don't think business is asking for a corporation tax cut. I don't think we can really afford it. But you can see the direction of travel. So you see on the one hand, maybe a desire to make the UK more attractive to business by reducing rates if you can afford it. Must stress that there was nothing about being in the EU that stopped us from doing it. And if you look at the direction of travel of the corporation tax rate, it went down, and Europe didn't really have any way of stopping it. But I could see a scenario under certain leaders where we see more populist taxes on wealth and on capital in a bid to maintain the support from the 52%, many of whom will have voted because of a sense that they have not benefited from the benefits of globalisation that we've seen in the last 20 years or so.
And that seems to be the central platform for Theresa May, her run for the Tory leadership, saying that Parliament's gotten out of touch with the average working person, doesn't realise just how tough it is for them. So that also is another interesting hallmark of where you might see some tax changes. But I just wonder how they're going to fund it. I mean, certainly tax cuts are going to be difficult to fund if you've got a 1 to 3% constriction in GDP over the next 24 months. I mean, we're not talking 5-10 years. It's going to happen quite quickly. And how do you fill that gap? It probably doesn't take you to the George Osborne, scare budget as part of the Brexit campaign, but there's going to have to be cuts from somewhere, or greater taxes perhaps.
Greater taxes. Again, just politically thinking of the budget, and I think we'll have to have an emergency budget. If it's not called that, it will be when the autumn statement takes place, late November, early December. But how is that Chancellor, whoever that Chancellor is going to be, going to stand up and say, we're going to cut social spending more? Yeah, it gets to a point where you can't cut much more.
I think that's right, and I think there's a lot of the anger reflected in the vote was because actually the cuts to services have led to longer waiting lists for GPs and infrastructure not getting the investment that it needs. I think that the Leave candidates were very good at blaming that all on EU membership, but actually it's a structural issue for the UK economy. How they will square that, if and when they're in a position to address it, well, whether they will address it or not, who knows? But so at some point, someone will have to. There'll be the large sound of, I think, chickens coming home to roost. Okay, thank you both. Interesting times. We'll be continuing to explore these themes as they develop. But in the meantime, thank you for watching, and look out for the next installation from us.